is attorney Brianna Hauser. Representing the appellee, the state of Vermont, is attorney Evan Meenan.
Thanks very much, and good morning, counsel. We'll hear from counsel for the appellant first. Of course, please start by introducing yourself, identify your client, and then proceed.
Thank you, Your Honor. Good morning. Brianna Hauser on behalf of appellant Jesse Stevens. This court should reverse the unlawful restraint conviction for 3 reasons. First, the restraint was inherent in the nature of the aggravated domestic assault conviction and not criminally significant to sustain a separate conviction. Second, the state's theory on appeal that the relevant period of restraint is limited only to the period of restraint at the end of the incident was not advanced below, and so this court should reject it outright. And third, even accepting the state's theory on appeal, there would still be insufficient evidence of a criminally significant restraint, and this theory would create an additional sufficiency issue that there would be insufficient evidence of exposure to serious bodily injury, which is essentially exposure to risk of death or substantial impairment during that period.
Ms. Hauser, the jury was charged on the 2 separate events, and they needed to find unanimity on both charges, and it seemed to do that, did it not? Saying that there were 2 separate charges here, and the state had the burden to prove each of the essential elements beyond the reasonable doubt of each charge, and it seems like the jury did do that. So how do I distinguish the error there?
Well, the question for this court is whether there was sufficient evidence to put to the jury of a criminally significant restraint separate and apart from the underlying restraint inherent to the aggravated domestic assault charge. And so our position is that because the aggravated domestic assault charge here, it was in part that Mr. Stevens, the testimony was that Mr. Stevens had his hand on Ms. Stevens' neck throughout throughout this incident, and that was sort of the basis of the restraint. And it was also there was no kind of additionally criminally significant restraint aside from that. And what this court has said is that if the restraint for an unlawful restraint conviction is inherent in the nature of the underlying felony, in this case that would be the aggravated domestic assault, then it's not sufficient to warrant an independent prosecution for a separate unlawful restraint conviction. The evidence that the state points to here to support the sufficiency of the restraint, considering that evidence, the first, it suggests that the relevant period of restraint here was over several hours, but that's just not what the evidence is. Ms. Stevens testified that it was about 20 minutes from the time that they went out onto the front steps until when the police arrived, and that's the period of confinement that the trial court considered in its analysis on the Rule 29 motion. Next, any evidence that Mr. Stevens alternated between being affectionate and being intimidating was outside the relevant period for the analysis of this issue. But even still, that evidence has no bearing on the court's analysis of whether the restraint was substantial. In State v. Synod, this court considered a kind of similar evidence, which was that the defendant there alternated between fondling the complainant and intimidating her. But the only reason that that evidence was relevant there was because the defendant had been charged with lewd and lascivious conduct based only on the fondling conduct, and was charged with kidnapping for the 1.5-hour period during which he confined the complainant. And what this court said was that the confinement over the 1.5 period was substantially greater than what was required simply to commit the offense of the lewd and lascivious conduct. But that's just not the
You have 1 minute, counsel. 1 minute.
Okay. Next, the state's assertion that the confinement was at the end of this period of restraint, again, is not the theory it advanced below. In closing, the prosecutor argued that Ms. Stevens was not free to leave until after the assault was completed, and that the assault didn't stop until other people pulled up. So we're really talking about the same period of time that the unlawful restraint is alleged to have occurred as the domestic aggravated assault. And it's the restraint is just there is no restraint that is independent of the underlying conduct for the aggravated domestic assault. Finally, the state's suggestion that the confinement could have prevented others from hearing Ms. Stevens is entirely speculative and not supported by the record. This was happening on the front steps of the home outside. There was testimony that the neighbors did hear this and called the police, and when the car drove up at the end, Mr. and Ms. Stevens were immediately in view of the car. And so because there was insufficient evidence of a criminally independent restraint, the unlawful restraint conviction should be reversed.
Okay, thank you very much. Your time has expired. We'll hear from counsel for the appellee now. Of course, please start by introducing yourself, identify your client, and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which respectfully asks this court to affirm appellant's unlawful restraint conviction. The state's assertion is that the appellant's unlawful restraint of the complainant in this case was not incidental to his domestic assault of her. On pages 20 to 21 of the state's brief, the state outlines approximately 7 factors, depending upon how you group them together, 7 factors that this court analyzes to determine whether or not a restraint was incidental to any other offense committed at the same time. Pursuant to those 7 factors, when you lump them, when you consider them all, the defendant's unlawful restraint was not incidental to the domestic assault. The appellant was convicted of domestic assault for placing his arm across the complainant's neck, covering her nose and mouth to prevent her from breathing. The defendant, or the appellant, was convicted of unlawful restraint for pinning the complainant against the porch steps in order to assault her. He committed the first of these 2 crimes to prevent Stevens, his wife, from screaming and yelling for help. When that was unsuccessful, he then committed the second crime, as well as additional assaultive behavior, in order to obtain the complainant's phone, which for some reason he believed had his money in it. Thus, the latter crime and the latter restraint was not inherent in and did not facilitate the earlier assault. And that is true even if the appellant also restricted the complainant's movements during the first assault. In addition, the latter crime, the latter restraint, did increase the danger to Stevens because it included additional assaultive behavior. It also compromised her ability to call for help because he was trying to retrieve her phone. And that is true even if coincidentally help did arrive. And thereby, appellant's second offense reduced the odds that he was going to be detected. Now, that theory of the case is not new to this appeal. The way that his conduct was split up into those 2 separate offenses was the way that it was split up below, at a minimum, when the court denied the appellant's motion for a judgment of acquittal. And a summary of the court's decision appears on pages 12 to 14 of the state's brief. But that summary clearly identifies where the court drew the dividing line between the first domestic assault, which was designed to prevent the complainant from breathing, and the second unlawful restraint, which also included additional assaultive behavior, but which was designed to obtain her phone after he unsuccessfully attempted to drag her into the house by her hair. With whatever remaining time I have left, I'd like to address the issue of the exhibits 11 through 14, which were admitted into evidence. It's the state's position that those pieces of evidence were sufficiently authenticated. The test for authentication is not absolute certainty. The only thing that is required is that the sponsoring witness or witnesses identify the piece of evidence with reasonable certainty, and then the jury is the final arbiter of whether or not the exhibit is what it purports to be. And in this case, the complainant's testimony—
You have 1 minute, counsel. 1 minute.
Thank you very much. The complainant's testimony in this case was sufficient to authenticate all of these exhibits. On pages 10 to 12 of the state's brief, the state identifies approximately 18 pieces of evidence that support the state's position on authentication. And it's the state's position that all of the defects in that testimony, or alleged defects in that testimony, as well as the alternative inferences that could be drawn therefrom, were all appropriate things for the appellant to raise during cross-examination and during a closing argument, but they don't undermine the fact that the evidence was identified with, at a minimum, the necessary reasonable certainty to present the evidence to the jury. And in this case, Hittel is readily distinguishable for the reasons set forth in the state's brief. I see I have no time remaining. Thank you very much.
Okay, thank you very much. Does the appellant have any time?
Appellant has no time remaining.
I'm sorry.
Appellant has no
All
time
right,
remaining.
please call a conclusion of the hearing.
The next
Thank
hearing
you.
for the
Please
court.
call a conclusion of the hearing.